estate license exams for dummies. Part 3 is all mines, owning and transfer real estate. Chapter 6, owning real estate and interest. Review questions and answers. Most materials in this chapter is pretty standard regarding property ownership and the rights associated with owning property, although a few state-specific issues may be addressed on the exam. Make sure you know the vocabulary well and can tell the difference among the terms. Definitions are most commonly questioned items on the exam. Question number 1. Land improvement and all the rights of ownership is a good definition of A. Land ownership, B. Real estate, C. Real property, D. Property. Correct answer, C. Real property. The statement in the question is a definition of real property. Land ownership and the properties are too vague relatively to real property. The definition of real estate includes only land and structures, not rights. Question number 2. Which of the following is not a fixture? A. A fence, B. A dishwasher, C. A painting hanging on a wall, D. A dining room chandelier. Correct answer, C. A painting hanging on the wall. You may think that fixtures can only be inside the house, but that isn't the case, so a fence is a fixture. The only answer that may throw you a little bit is a chandelier, because many people take chandeliers with them when they move. When you take a chandelier with them, they do so by prior arrangements. The dishwasher is usually attached to the plumbing and electrical system of the kitchen. It stays if no arrangement exists to remove or replace it. Of course, if the dishwasher is in your house, he or she will be going with you. When you sell the house, the painting is correct because it is a portable and not permanently attached to the structure. And unless an agreement exists to leave it, most people consider it to be personal property. Question number 3. When a man wants to donate property to a conservative group, he agrees to the organization can take title of the property as soon as an education center is built on the property. What kind of estate is he creating? A fee simple absolute, B, a fee simple condition precedence, C, a fee simple condition subsequence, or D, fee simple determinable. Correct answer is B, fee simple condition precedence. The word precedence means before, so the educational center has to be built before the property ownership passes to the conservative organization. Fee simple absolute is the most complete form of ownership that has no conditions. The word subsequent in the fee simple conditions means after. The conservative group, in this case, has to build the educational center after it receives ownership of the property. Fee simple determinable would have been correct if the language in the question had talked about ongoing conditions, such as so long as the property is used for educational center. Question number 4. Sally owns a house that she will allow her sister, Fran, to live in for the rest of Fran's life. Upon Fran's death, the house goes to Sally's children. Which of the following best describe the interest Sally has in the property? A. Ordinary life estate, B. Life estate per due, C. Simple condition subsequent, D. Leasehold estate. Correct answer, A. Ordinary life estate. An ordinary life estate is an interest conveyed to a person that exists for as long as the person, the one who receives the interest, is alive. Life estate per view is for life estates that exist for the life of the third party. someone other than the person receiving the life estate. Fee simple conditions subsequent is an actual transfer of ownership with the condition. Leasehold estates is an interest a tenant has in a rental situation. Don't be confused by the fact that the property goes to Sally's children upon Fred's death. Question number 5. Joe rents office space from Fred. What type of interest does Joe have? A. Leasehold interest. B. Lease fee interest. C. Fee simple defeasible. D. Fee simple absolute. Correct answer A. Leasehold interest. Remember, the tenant holding the lease. The landlord has a lease fee interest. The fee simple defeasible and fee simple interest are ownership interests in the property. Therefore, theoretically, the landlord could have one of these interests, but because of the question asks about the tenant's interests only, leasehold interest is correct. Question number 6. You own property on a river that is a regular commercial boat traffic. What rights do you most likely have with respect to the water? A. You own the center line to the river. B. You have no rights to the water. C. You have rights to use the water and down to the edge of the water of the river. D. You can use water and own the land under the water to the midpoint of the river, but the state owns the water. Correct answer, C. You have the right to use the water down to the edge of the river. Correct answer is C. Alright. Reparson's rights, which is that you have navigable rivers and streams, gives you the rights only to the water's edge and the use of the water. If the river weren't navigable, you would have owned it to the center line. Answer A. B is incorrect because property border water generally have some type of rights with respect to the water. Answer D is determination of the statement that's taken as a whole is incorrect. Question number 7. What are the water rights called for oceanfront property owners? A. Reparson rights. B. Littoral rights. C. Defeasible rights. D. Qualified rights. Correct answer is B. Littoral rights. Littoral rights are those of the rights granted by owners whose land borders oceans, bays, and large lakes. Reparson rights are those rights granted to property owners or land next to rivers and streams. Defeasible rights have to do with the defeasible estate with the interest with a certain condition attached to it. A qualified estate is similar to qualified rights. Question number 8. The right of the state to control water rights in some states is called A. A bundle of rights theory. B. Littoral rights. C. Reparson's rights. D. Doctrine of prior appropriation. Correct answer is D. The doctrine of prior appropriation. The doctrine of prior appropriation exists in states where water rights are an issue to have to do with controlling the use of water. Littoral and reparson rights are the rights automatically granted to landowners whose property abuts bodies of water. The bundle of rights theory is the overall theory of all the rights property owners have. Question number 9. The theory that best describes the rights that you get with a piece of real estate is A. The doctrine of complete rights. B. The bundle of rights. C. The development rights theory. D. The fee simple absolute. The correct answer is B. The bundle of rights. The fee simple absolute may have confused you here, but it really isn't a theory. Instead, it describes the highest form of ownership and may apply only in some cases. There is no such thing as a doctrine of complete rights or development rights theory. The bundle of rights theory is the best answer. Question number 10. Receiving back the property you give in a life estate when a life estate ends is best described as A. Conveyance, B. Transfer, C. Revision, D. Remaindering. Correct answer, C. Revision. Revision is the correct term, with the property interest automatically returning to you, that it comes back, which is the way the question is worded. A remainder interest conveys the rights to a third party, such as children if the life estate ends after you die. Conveyance and transfer are generally associated with straight changes in ownership from one party to another. And those are the question answers for part 3. It's mine, owning and transferring real estate. Chapter 6, owning it, real estate interest. Thank you very much.